Now, the fallout of the child serial killer Lucy Letby's refusal to appear for her sentencing continues as the government vows to change the law to force defendants to attend court.
But how would any change in the law work in practice? Well, prison officers already play a crucial role in getting defendants to and from court. And Mark Fairhurst, who's the chair of the union which represents them, joins us now in the studio. Morning, Mark. Thanks for coming in. So you have the responsibility, prison officers have the responsibility at the moment of getting a defendant to and from court, but also from the cells into the court.
Yeah, that's correct. We've got court staff who are predominantly private sector who have that responsibility. I'm not sure we need a change in legislation, actually, because it's always been within the gift of the judge to order the defendant to appear in the dock. And there's been many occasions when the public sector ran the courts that we were forced to use, restraints on prisoners to get them into the dock and cuff them so they could hear the sentence and hear what the impact statements from the victims and their families, actually said when they were read out. So do we actually need legislation? I'm not sure we do.
So if a change in legislation isn't the answer, what is then?
Well, it's down to the judge to decide if they want that defendant to appear in the court. They may be acting on intelligence, and what you've got to remember is how traumatic will it be for the families and the victims if that defendant causes disruption in the court? So if they're abusive towards the families or abusive towards the judge, or they continue to act violently in the dock, that could be very traumatic for everybody. So there are alternatives that we could consider. We've got technology now that we could use. A lot of prisons have video suites, so we can remotely do court cases from a prison. So it's quite practical that we could take a prisoner from their cell in a prison to the video suite where they could witness the sentencing, and we have the facility there to mute sound. So that might be more practical, but this is all about the victims and their families. So often their voices are unheard. Let's ask them what they want. I'm happy to sit in a room with them and tell them what the practical implications are of a change in legislation. But let's ask them what they want.
Yeah, well, we know what the families of Letby's victims have said this week is that they thought it was a slap in the face, that she wasn't there in person in the courtroom to hear the sentence, that they didn't get that chance to tell her face to face the impact it had had on them. And I wonder, who knows what they're going through at the moment, but I wonder whether they might say, yeah, okay, a video link where a defendant hears the sentence is one thing, but they want them in the room. They want them forced to be there.
Yeah, and I agree with that. If the victims want that defendant in front of them so they can relate to them exactly how it's affected them, because they are the true, life sentences, aren't they, for the victims? So let's make it happen. The judge can order it, but if the judge is not going to order it, there must be a good reason why.
But even my understanding is, even if the judge orders it, a prisoner can still refuse to leave the cells. And my understanding is you can use reasonable force, but beyond that, you can't physically manhandle someone to the dock if that's not possible. And it is also presumably dangerous for your staff as well.
Yeah, so what would usually happen, the judge would say, I want that person to appear in front of me, and we would restrain the prisoner, put them in cuffs, and escort them to the dock. So obviously the practicalities of that are, what happens if that incident, turns extremely violent and people get injured? Staff and the prisoner get injured, they mightn't be able to appear in that scenario. Also, our staff are wide open to allegations from the prisoner of assault during any restraint, so that's another thing to consider. But we have had it in the past where the judge has insisted that person appears in the court, and they've been forced to appear in the court, so that's still within the gift of the judge. But we need to look at alternatives. I understand that the victims and their families want justice, and quite rightly so, but let's look at alternatives if that's not practical, because the last thing I would want to see is those families going through even more trauma because of a disruption in the dock from the defendant.
What are those alternatives? You're talking about technology and video links. I suppose once you start offering that as an alternative, once defendants know that's a possibility, no one will ever appear in court for sentencing.
So that's why we need to be more robust with people who refuse to hear what sentence they're going to receive and refuse to stand in front of the victims and their families and hear those impact statements. It's about time we started listening to the people who don't commit crime, to the victims and their families, and being more robust with these defendants who refuse to appear. Let's get them in the dock if that's what people want.
How difficult is this decision that the government's got to make?
I don't think it's difficult at all. Let's listen to the people who really matter in all this, and that's the victims and their families. And if we have to force people to appear in the dock, then we have the staff to do it, we have the training to do it, we have the skills to do it. Let's make it happen.
Mark Fairhurst, National Chair of the Prison Officers Association, thanks for coming in this morning.
You're very welcome.
Thank you.